I don't know a lot about New Mexico, but the temperature, what I just checked now, was about 85 degrees, which seems to be approximately the same number of the constitutional IQ of the governor of New Mexico, who just entered an order saying that you cannot carry a gun even if you have a license for open or concealed carry in certain cities in New Mexico. A blatant violation of the Second Amendment and the Constitution. Stay tuned. Let's break down this crazy, insane order by the governor of New Mexico. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, How the Anti-Gunners Intend to Take Away Our Right to Keep and Bear Arms Step by Step. I lay it all out in a detailed book so we can all be on the same page, recognizing where the antis are going to go, because once we know where they're going to go, it increases our chances of being able to stop them. Check out First They Came for the Gun Owners if you don't already own a copy. All right, so it's late on Friday night, and I can't believe I have to deal with a moronic order, a blatant violation of the Second Amendment, and a thumbing to the nose of the U.S. Supreme Court precedent by the governor of the state of New Mexico. Now, this is Governor Michelle Lujan Grisham. I hope I pronounced that correctly. So Governor Grisham came out and said that she is suspending the right to carry guns in public across Albuquerque and the surrounding county for at least 30 days amid a spate of gun violence. Now, this is moronic. That is like coming out and saying that you're going to suspend the ability to practice your religion in a city for 30 days, or we're going to ban free speech rights because we have a contested election coming up and I don't want people to get angry with each other, so I'm going to suspend the First Amendment for 30 days. That is how moronic this idea is, and this order is, and unconstitutional this idea is. This order is by Governor Grisham. Now, let's just go through the highlights of why this is absurd and unconstitutional. I'll make it quick. First of all, the U.S. Supreme Court has already said that the Second Amendment right to keep and bear arms includes the right to carry guns for the purposes of self-defense in public, and it is a fundamental right. Specifically, the court wrote in its conclusion in NYSPRA versus Bruen, of course, that the constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. So therefore, just like you cannot enter an order or declare for 30 days for any reason that the First Amendment has been suspended, that the right to go to church or to practice your religion has been suspended, or your right to exercise free speech has been suspended, no governor could do that, nor could the governor suspend the Second Amendment. Because again, as NYSPRA versus Bruen teaches us, it's not a second-class right. That is, by the way, also what the Heller and specifically the McDonald court said as well. So the Supreme Court in the McDonald case versus the city, that's McDonald versus City of Chicago in 2010. So again, black letter Supreme Court precedent that the governor of New Mexico is simply ignoring. The second thing, of course, is she's trying to argue that, well, there's certain cities that meet a criteria of dangerousness and therefore we get to ban the ability to carry guns in those cities, specifically Albuquerque. Now, here's the thing. The Supreme Court already confronted this argument in Bruen about whether or not you can ban guns in the cities or restrict the ability to carry guns in the city because people congregate or there's police or whatever. All these arguments were completely and utterly rejected by the U.S. Supreme Court in NYSPRA versus Bruen. Keep in mind that one of the famous examples that the court had to confront in Bruen, or use in Bruen really, was the fact that during the Boston Massacre trials, and just to jog your memory, before the American Revolution, you had the Boston Massacre, which is a mass shooting by British soldiers of American colonists. And John Adams, who defended these British officers during the Boston Massacre trial, said that in lower Boston, right, the most concentrated urban area of America, arguably at that time, in downtown Boston, that everyone had a right to carry guns. But nevertheless, you have a right to use self-defense, and he defended the British officers, saying that they had a right to defend themselves, but he did not deny that everyone there had the right to carry arms. That was John Adams talking about downtown Boston at the time of our founding. So the Supreme Court points out that the Second Amendment applies to cities like anywhere else. So the Second Amendment right to keep and bear arms, including the right to carry guns in public for self-defense and other lawful purposes, applies just as much to people who live and walk and wander around the city of Albuquerque in New Mexico as anywhere else in that state. The next point, of course, why this order is unconstitutional is there's simply no founding era analog. Just to jog everyone's memory, the Supreme Court in NYSPRA versus Bruen made it crystal clear, and they already had done this in Heller, but lower courts pretended not to notice. So NYSPRA versus Bruen came out and said there is no interest balancing. You cannot balance away a Second Amendment right of anyone based on some argument that guns are good or guns are bad. You can't have that kind of interest balancing test because, as the Supreme Court has repeatedly said, the Second Amendment in and of itself is the result of a balancing of interest between the good and the bad of guns already. So that is how we resolve it. So specifically, the only way that this order by the governor of New Mexico could possibly stand, which of course it can't, is there would have to be some sort of historical analog law similar to this at the time of the founding. And of course, there is no such thing. Just to remind you, in NYSPRA versus Bruen, this is what the Supreme Court said about why interest balancing is not acceptable. And the only way you can justify a modern day gun control law, which obviously this ban on carrying guns in public is a gun control law, even though it's in the form of an order and not a statute. This is what the Supreme Court said in Bruen just in 2022. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To carry a gun, obviously, is protected by the text because the right to keep arms means the right to keep, which means to possess, the right to bear, which means to carry. So here, banning carriage of firearms in Albuquerque constitutes a implication or violation of the text of the Second Amendment. So the only question is, what happens next? Well, the Supreme Court tells us. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside of the Second Amendment's unqualified command. That's what the Supreme Court says. So the question is there any law that existed or any regulation or anything at the time of our founding in 1791 that could possibly justify a governor entering an order saying you can't carry guns in public? And the answer is undeniably absolutely not. In fact, it was just the reverse. Because keep in mind, it was orders to try to take away guns from the colonists that ultimately triggered the American Revolution. So the American colonists who, among other things, wrote the Second Amendment were very sensitive to the idea of government taking away guns, and they hated the idea, which is why we had an American Revolution, which was fought over gun control. Remember, the Battle of Lexington and Concord occurs when the British leave Boston to go to Lexington and Concord. They weren't there to rape and pillage the countryside of Boston. No, they were there specifically to take the guns and the black powder ammunition from the colonists, and they were intercepted and prevented from doing so. That's what started the American Revolutionary War at the Battle of, again, Lexington and Concord. It was fought and started over gun control. So the idea that here you have this governor saying that you can't carry guns in public in violation of the Second Amendment, obviously there's no historical analog law that justifies this behavior at all. That is clearly not the case. Beyond that, if you think about it, at the time of the founding, and this was also discussed in the brief in NYSPRA versus Bruen, when the founding fathers had a concern about the dangerousness of a particular location, such as, let's say, a church, where they feared a church could be attacked by Indian marauders, let's say, their answer was not to ban guns and make churches, for example, government-mandated gun-free zones. No, instead, they actually, in some instances, required Americans to bring guns to church to protect that. So here you have an example. The governor of New Mexico is going the absolute opposite direction, where she's claiming that she wants to have this 30-day moratorium banning the carrying of guns, whether it be open carry or concealed carry in New Mexico, in Albuquerque specifically, on the grounds that she is unhappy with gun violence, which we're all unhappy with gun violence, but that doesn't excuse the violation of the Second Amendment. Again, the founding fathers would say you do just the opposite. You follow the teachings of 18th century criminologist Cesar Beccaria, and you basically make sure that people carry guns, because if you ban the carrying of guns, you do not make life easier for the law-abiding, you actually make life harder for the law-abiding and easier for the criminal, because as Cesar Beccaria taught us, and I've written about this, we've talked about him before, that laws that ban firearms make it easier for a armed man to attack an unarmed man, because of course an unarmed man can be attacked easier than an armed man. That's a no-brainer. It's not an NRA slogan from the 21st century. It's actually an 18th century discussion by Cesare Beccaria, a criminologist that was very important in Italy, that our founding fathers knew and loved. Specifically, Thomas Jefferson and John Adams both specifically wrote about Cesare Beccaria and his views on, among other things, the right to self-defense. Very influential, and Beccaria came out with the absolute opposite conclusion at the time of the founding from this governor here in New Mexico. The last 2 points I want to make quickly is NYSPRA versus Bruen. Specifically, the Supreme Court says that you cannot declare a part of a city or a sensitive place or a government-mandated gun-free zones. Specifically, if you look at the Bruen decision, it says that New York cannot characterize New York's law dealing with back then may issue permitting regimes as a form of sensitive place. Specifically, the Supreme Court went on to say, expanding the category of sensitive places simply to all places of public congregation that are not isolated from law enforcement defines this category of sensitive places far too broadly. New York State in Bruen's argument would in effect exempt cities from the Second Amendment and would eviscerate the general right to publicly carry arms for self-defense that we discussed in detail in this case, Bruen. Do you see what I'm just saying? They're specifically saying that cities are not exempt from the Second Amendment. And specifically, the Bruen decision goes on to talk about Manhattan as an example of a city that you cannot ban guns in because it's a city, which is a lesson apparently the lawyer's advising, or maybe she doesn't care, the governor of New Mexico. They failed to notice this. But yes, NYSPRA versus Bruen, the Supreme Court said, quote, there is no historical basis for New York to effectively declare the island of Manhattan a sensitive place simply because it is crowded and protected generally by the New York City Police Department. That's what the Supreme Court said. So again, it is clear that the Supreme Court precedent of Bruen says that you can't say that you can't have a gun or can't carry a gun in a city because it's a city or anything like that. That is a no-go zone. And last but not least, keep in mind we have some experience with governors trying to exercise essentially executive fiat to simply use a pen and a phone to declare a public health emergency and thus take away constitutional rights, because that is what some governors tried to do during the quote-unquote COVID public health emergency by, among other things, closing gun stores and things along these lines. But as you know, those failed ultimately, like in places like New Jersey, because there were lawsuits brought. The Department of Justice and the federal government said that, for example, gun stores are necessary and essential services, so therefore they could not be closed. And again, even though some governors thought it was a great idea to try to close gun stores and gun ranges and the like in the name of public health during COVID, that ultimately failed because, of course, the right to keep and bear arms includes the right to train and the right to acquire firearms, and therefore those attempts by waving an executive wand and just closing down gun stores failed miserably during the public health crisis of COVID. So by analogy here, where the governor of New Mexico is trying to claim a public health crisis of quote-unquote gun violence, which is a propaganda term, there's no such thing as gun violence. There's only people that use guns for mischief and criminality, but there is no such thing as gun violence any more than there's such a thing as car violence and the like. Nevertheless, the governor of New Mexico is trying to say that she has the authority to suspend the Constitution, specifically the Second Amendment, but she would never try this with any other aspect of the Constitution, including, I would say, let's say, elections. Nevertheless, that is what she's trying to do with her order. It says you cannot carry guns in Albuquerque, whether you have a permit or not. And, of course, this is blatantly unconstitutional. As to what's going to happen, I suspect there are plaintiffs that are already being lined up to sue in federal court the governor and the state over this order to get an immediate injunction. I think that will likely prevail. I should warn you in the Second Amendment community that New Mexico is a pretty blue state full of Democrats. So I suspect that any federal judges that have made the federal bench in New Mexico, and ultimately to some degree in the 10th Circuit Court of Appeals, I would say overall they're generally not good on the Second Amendment, not good on these kinds of issues. Nevertheless, the Supreme Court precedent is so clear here, and this is such a blatant violation of the Constitution. I hope that any federal judge that gets this case is going to see this as an obvious violation of the Second Amendment and will stop it and thwart it, because it is simply insane as I see it. Okay, folks, hope you learned a little bit something here at this breaking news out of New Mexico. If you haven't subscribed, please do so, and don't forget to follow me on Twitter or X at 4 Boxes Diner, and we'll see you again soon here at the 4 Box's Diner.
Orders up. Table 2A.